Hello, and welcome to ULV Justice Center Civil Litigation Pleadings Stage. Glad to have you. As a reminder, the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you consult with an attorney. Typically, civil cases are started by one party, the plaintiff, which is the party suing, who files a complaint with the court which describes the situation at hand and explains what they want in return and why they feel they are entitled to what they are asking for. It also identifies the defendant, which is the other party being sued, thus initiating the lawsuit. Pleading stage. During the pleading stage is where you will file your complaint to start your case, serve the complaint, and respond to the complaint. Filing a complaint to start your case. The following items comprise of the complaint packet, which are the documents that you need to file with the court in order to start your complaint. First, you have the civil case cover sheet. This is a judicial counsel form, form CM010, and all you need to do is basically complete the top portion, which is called the caption, and then we have the complaint. In the complaint is where you will plead all the allegations against the person who harmed you. And you want to make sure that you know all the elements for the cause of action so that you can talk about each element and relate to the facts of how you believe you were wronged. This is the first pleading in a civil action. The fact chart from the previous section in the pre-litigation page will help you to tie the elements to the cause of action to the facts. Drafting the complaint. For your reference, there is pleading paper. All you need to do is click on it and it will take you directly to it. The caption. The caption of the complaint identifies the person or attorney filing the complaint, the court and the county where the complaint is being filed, the title of the action, and the title of the document. The body. The body is the most important part of the complaint. It contains jurisdictional allegations, also known as venue allegations, and this is where the plaintiff states facts regarding personal jurisdiction over the plaintiff and the proper venue. The plaintiff makes necessary DOE allegations, basically stating that the plaintiff is ignorant of possible other defendants whose names and or identities are unknown to plaintiff. That's why they are called DOE. General allegations, also known as the summary. General allegations consist of a short synopsis of the facts of the case. So briefly just tell the story, naming the causes of action and using the relevant facts as they pertain to the causes of action. And you want to keep it concise. Next, you have specific allegations, which is also known as the causes of action. Each cause of action shall have its own heading, identifying 1, the number of the cause of action, 2, its nature, and 3, the plaintiff asserting the cause of action, and finally, number 4, the defendant against whom the cause of action is asserted. Using the fact chart, it will assist you in pleading the causes of action using one paragraph for each element. Only plead the facts that relate to each of the elements. Do not plead unnecessary facts or conclusions. Since some of the facts may be relevant to different causes of action, be sure to incorporate by reference each paragraph when stating a new cause of action. The prayer for relief. This states what the plaintiff is asking for by way of remedy for each cause of action and the amount of money, damages, or other relief that they want. The subscription and verification. This is basically you signing the complaint, which is the subscription, and verifying that all the information stated in the complaint is true to the best of your knowledge under oath. The summons. This is a mandatory judicial counsel form, and its purpose is to satisfy the due process of law protection under the 14th Amendment of the United States Constitution, which requires that a person be given notice that a suit is pending against them and what their risks and obligations are. The summons is prepared and submitted to the clerk with the complaint. The clerk will then issue the summons at the time of filing by signing it and stamping it with the court seal. Then you need to serve a copy of the complaint along with the summons on the defendant. The form summons warns the defendant that they are being sued, that they have a limited amount of time to file their response, which is 30 days. And if they fail to respond, they may lose the case by default, and wages, money, and property may be taken without further warning from the court. To complete the summons, you need to identify the parties, making sure to correctly spell their names and their capacities are correctly stated. Insert the name and address of the court. Insert the name and address and phone number of the plaintiff or the plaintiff's attorney. Serving your complaint. After you file a complaint and have the summons issued, a copy of the summons and complaint must be delivered to each defendant. This is called service of process. Technically, you have 60 days after the complaint has been filed with the court to serve the defendant, but it is good practice to serve the defendant immediately after filing the complaint. Once the defendant has been served, proof of service must be filed with the court. Below are the most frequently asked questions that I will answer regarding service of process. Number 1, who can serve my summons and complaint? Service of process must be completed by a person who is not a party to the lawsuit and who is over the age of 18. Service of process can be done by a sheriff or a private processor as well. The fee is usually $17 plus $2 for each mile traveled. It varies widely, so you might want to double check with the court with whom you are filing a complaint with. How do I prove to the court that my summons and complaint was served? The person who serves your summons and complaint should fill out a proof of service of summons and an affidavit that includes all the documents that were served in addition to the summons. And then once the service is completed, they should give you the proof of service of summons back to you, signed and dated by them, and then you should file it with the court immediately. How long do you have to serve a defendant? Once the complaint has been filed with the court, you typically have 60 days to serve the defendant, but I recommend serving the defendant immediately after the complaint has been filed with the court. How do I serve an individual? Each defendant must be personally served with the summons and complaint. Personal service means that the defendant must be handed a copy of the summons and complaint. The only exception to this rule is if the summons and complaint are served at a defendant's home. A process server can leave the summons and complaint at their home address with any suitable adult, someone who is at least 14 and who lives there. However, the summons and complaint must be given to a person and simply cannot be left at the front doorway. How do I serve a business? If you are suing a corporation or other business, you generally must serve a person who is called the registered agent. All corporations, limited partnerships, and limited liability companies are required by law to designate an agent to accept service of lawsuits on behalf of the business or corporation. Corporations must provide the name and address of this agent, and you can always go to the California Secretary of State website and do a business entity search and look up the agent of process there. What if I have been able to serve the defendant? If you have made several attempts and failed to serve your defendant, you can ask the court for permission to serve the defendant by publication. To get the court's permission to serve by publication, you must file a motion. You will need to demonstrate to the court that you have a valid cause of action against the defendant and that the defendant you are trying to serve is necessary to the case. You will also need to describe all your past attempts to serve that defendant. Responding or answering to a complaint. If you received a summons and complaint, most likely you are being sued. Being sued and having to go through the whole process can be a very stressful experience. Although it may be tempting to ignore a summons and complaint, ignoring a lawsuit does not make it go away. Ignoring it could actually result in the court awarding a money judgment against you by default that can lead to your wages being garnished and even your property being taken. How you choose to respond to the summons and complaint depends on the facts of your case. The following steps can help you decide how and whether you want to respond. Step number 1, calculate your deadline. However you decide to respond to the lawsuit, it is important to remember that there are deadlines to take action. Essentially, you have 30 days, including weekends and court holidays, to file a response with the court. If you do not file a written response within the required time, the plaintiff can ask the court for a default judgment against you for everything they asked for in the complaint. Step number 2, evaluate your options. Once you have been served with a complaint, you have a number of options to choose from and a couple of decisions to make. You can either negotiate a resolution, file an answer, file a motion, or attack the complaint. Negotiating a resolution at any time during the case, you can talk to the plaintiff and try to resolve the dispute. Just make sure you keep track of your 30 days that you have to respond. File an answer. Filing an answer is probably the most common way of responding to a lawsuit. An answer is your opportunity to respond to the complaint's allegations and legal claims, and it allows you to raise affirmative defenses, which are facts of legal arguments that you raise to defeat plaintiff's claim. Filing an answer prevents the plaintiff from getting a default judgment against you, and ultimately it signals the court and the other side that you intend to defend the case. Click here for a list of possible affirmative defenses. Answers typically contain admissions, denials, and affirmative defenses. File a motion or attack the complaint. You can learn more about your options relating to motions in Module 4, and attacking the complaints is more thoroughly discussed in Module 3. Step number 3, prepare a response. Click here for a sample of what a response might look like. Step number 4, file your response with the court and be sure to make 3 copies plus the original. The original and 2 copies will be filed with the court. And number 5, serve the other side with the leftover copy.